Sometimes there's no one else who loves me like you used to. Sometimes we're not ourselves. There's no one I can turn to. And I know all the feelings that we shared are in the past. And I know your relationships are never meant to last. And I'll take some time, but I'll be alright. We're moving on. We're moving on. I know times are
Good evening, everyone. A pleasant good evening to all our members and welcome to part 2 of our mortgage webinar series entitled Legal Guidance in Purchasing Your Property. My name is Kelly Traveley-Hack and I'm the General Manager at Cannings Employees Credit Union, and I'll be your moderator for this evening's session. As we would have learned in part 1 of this webinar series, purchasing property is a significant investment and it does take time. And in some cases, it is the single largest investment that you will make in one's lifetime. It's therefore very important that we understand the legal processes, the legal documents, and the fees that are involved in these types of transactions. Before I introduce our presenter, please allow me to share a few house rules. So throughout the presentation, all the mics will be muted. At the end of the presentation, we will have a Q&A session. So if you have a question at that time, you can raise your hand and you will be called upon to ask a question. Alternatively, throughout the presentation, you do have the option of typing your question in the chat box and it will be addressed during the Q&A session. So today's seminar is expected to run approximately an hour and a half. And the seminar is being recorded so that the recording, as long as the presentation from today's webinar, will be uploaded to the library section on SECU's website. It is my pleasure this evening to introduce Ms. Helen Arahu, partner at the firm MG Daly & Partners and one of the attorneys on SECU's panel. Helen joined the firm MG Daly & Partners in 2012, and she became a partner in 2016. Helen provides conveyancing, probate, and real estate advisory services to the firm's clients. Helen is intricately familiar with the real estate law and the law of landlord and tenant, and has been relied upon as an expert in civil litigation. She is well versed in transactional matters and the law, practice, procedure, and preparation of legal documents in support of conveyancing and probate matters. Prior to joining the firm, Helen gained invaluable experience with the operations, practices, and procedures relating to conveyancing and the preparation of legal documents related thereto while performing services as a conveyancing clerk for a long-standing conveyancing practitioner. Helen has specialist postgraduate training in marketing, business administration, business management, economics, and private acquisitions. She is a former senior ordinary member of Council of the Law Association, having served during the period 2019 to 2022, and currently serves as a member of the Law Association's Corporate, Commercial, and Conveyancing Committee. She is also a businesswoman, an avid reader, and a traveler. So we are in a very, very good hands this evening. So I hand things over to you, Helen.
Good afternoon, everyone. Thank you, Kellyanne, for inviting me to do this presentation for your members. And I hope that the webinar that I've put together this afternoon will be informative and that you will all learn something. And as Kellyanne had indicated, please feel free to ask questions. We'll try our best to answer them as quickly as I can within the Q&A session. I have agreed with Kellyanne that any questions that we are unable to answer, that I would assist in providing clarification subsequently, but that would be done on email from Kellyanne to me and then relayed back to her for onward transmission to whoever asked the question. So please, if you haven't done so already, please let Kellyanne and her team have email contact for you if your question wasn't answered at the time. Okay, so I would like to get into the presentation now. All right, so what I'm going to be talking about today is giving you guidance as to how conveyancing practice works in Trinidad and Tobago, a brief overview of the process in being able to understand what do you need to do in order to purchase property, some information also in respect as to what to expect in terms of costing on legal fees and stamp duty. So the first thing that I would like to do is, can we go to the next slide? All right, so the number one question you need to find out is, do you need an attorney for a conveyancing transaction? And it's important to understand that it is critical that you retain the services of an attorney at law as early on in the process as possible. All deeds in Trinidad and Tobago by which property is transferred or mortgage must be prepared by an attorney at law. It's important to understand that all attorneys are qualified to prepare deeds, but not all of them practice within the conveyancing practice. And it's important for your own protection that you really go and try to find someone who specializes in residential property transactions, as they will be best versed in that area of law and be able to guide you better. Okay, so that the next slide. So important to understand, a conveyancing attorney is a specialist in the legal aspects of purchasing or selling a property and handles all of the legal aspects of buying and selling property, including examining documents to ensure you're getting a fair deal and verifying that the contract you're signing is valid and legal. So the documents that we are talking about here would be the deeds that form the title to the particular property, the agreement for sale for the that you would enter into with your vendor for the transaction, and being able to look at those documents to make sure that you are not entering into a contract that it is going to be difficult for you to comply with, and also to give you proper protections, because there are certain things that need to be included in an agreement for sale for your protection. One of the important things to understand is that any transaction dealing with land in Trinidad and Tobago must be done in writing. So a verbal contract is not considered enforceable. But you can reduce it to writing. It doesn't have to be a complex document. It can be a very simple document, but simple documents can sometimes leave particular important aspects excluded, and that is why an attorney at law is always the best course of action in preparing your agreement for sale. Next. So what do we do as conveyancers? When we are dealing with the transaction, we will review the vendor's title deed, particularly to bring certain matters that may be of importance to your attention, to help you understand whether the land is freehold or leasehold, whether it is what is called a common law deed, which is what most of us would understand, or what would be deemed land held under the Real Property Act, which is the two land laws that exist in Trinidad and Tobago, and the two those two law systems exist side by side, but do have particular characteristics to each of them that are important for a conveyancing attorney to know and to be able to guide you through as to the types of documents that are needed for the transaction. There are times when the conveyancing process is not as straightforward as, it's not simple as just walking into the grocery and picking up a can of meat or a can of peas and walking and going to the cashier and paying it. There are particular things that need to be addressed and looked for. It's important for purchasers to understand that the laws in Trinidad and Tobago with respect to land transactions are very much caveat emptor. It means that you need, as the buyer, to be aware of any circumstances surrounding the property. And that is where the services of the attorney are important in doing the necessary work and asking the right questions to make sure that what you are getting is something that you understood to be the case, as well as something that suits your purpose. You wouldn't want to buy in an industrial area where if you wanted to build your home, and those are matters that are important to understand, as well as also you wouldn't want to be buying agricultural land to be able to get the benefit of the stamp duty exemptions that I'll talk about in a little later. And those are the kind of simple things that we as conveyancing attorneys will know as a matter of course, because this is what we do day in and day out. This is our bread and butter. Right now, we have a lot of land development going on, and those would be considered like new builds. And there are particular concerns that you would want to make sure are looked after in the contracts. And it's important to get a conveyancing attorney who deals with those things and understands the things to look for. So looking at things to make sure that there are provisions for defects in the character of the building, what kind of provisions there are for that, what are your completion dates, what are the requirements which the vendor can call on you to close your transaction, kind of helping you understand the timelines that would be needed, asking the necessary questions with respect to statutory approvals. And those are the matters that we really look at to be able to guide you in terms of purchasing the property. It's important to understand that you as a purchaser are entitled to have your own attorney look at the title and prepare the conveyancing documents. If you are taking a mortgage, however, the mortgage company that you are taking your loan with, they will have a panel of attorneys that they feel trusted, and then the mortgage document will usually have to be prepared by one of the attorneys on your mortgagee's panel of attorneys. Next. So the next step that we need to understand is once you have found your attorney, you must give them instructions to get the process started. Usually you come to an attorney after you've already viewed the property and reached out to the vendor, and you all have agreed on a purchase price and any other special terms that you would have within the contract, which you would then disclose to the conveyancing attorney. You would have to provide information such as the purchase price, whether you all have agreed a deposit, which is usually 10% of the purchase price. If you've agreed any particular terms and conditions, being let into possession or occupation prior to completion, as well as the timeline, whether you are going to use the standard 90-day closing, you've asked for a longer closing for any particular reason, or you've asked for a shorter closing. And those are all matters that would need to be disclosed to your attorney when you go to them to help to assist with getting the agreement for sale prepared. Okay, so one of the other things that's important to understand is that all conveyancing attorneys need to be FIU registered, and in going to them for them to prepare documents or to act for you in the conveyancing transaction, they have an obligation to do their what is called their due diligence and to get some information from you, and the attorney in the matter will advise you what documents they need from you. You will usually be asked to fill out a know your customer form to provide confirmation as to where you are getting the funds for the transaction, and then of course in how it is that you are able to fund these things. So basic documents that you would have to supply would be ID documents, a document showing proof of address, documents to show proof of income, and then of course the most important, the proof of funds. The purchaser's attorney will liaise with the seller's attorney if they have an attorney at law. If all that is involved is the real estate agent or the seller themselves, they will then have that conversation with those persons in order to get things rolling, to understand who's preparing the contract, etc., who's paying the fees for the preparation of the contract, because that is something that can sometimes be questionable. Usually, if you ask your attorney to prepare a document, you are responsible for their fees. But it's not unheard that vendors and purchasers share the cost of an agreement for sale, or that they each bear their own attorney's costs, depending on what is happening. And once the document, we will then discuss with the attorney on the other side, or prepare the draft document and provide it to parties within the transaction for the for review prior to signing. One of the important things that we will need to get, of course, is the title deed of the vendor, so that we would know what type of property we're dealing with, to make sure that we prepare a document in line with the type of title that the property has. Next. So once we have finalized the agreement for sale, there are two things that can happen. Either the search process will be done prior to entering into the agreement for sale. That has the benefit of being able to understand if there are any particular challenges with the title before you pay down your money. And it gives you then the option of saying, is this something that you are willing to wait for whilst any issues, etc., are fixed? Or it may be, and which is more likely the case, is that the agreement for sale is signed and the title searches are commenced subsequently. The title searches are where we would make requests to have searches conducted at the land registry. So that's the Registrar General's Department, where all original deeds for all property transactions in Trinidad and Tobago are lodged. There is a system that we use that the attorneys have access to, as well as we would work with search clerks, either in-house or freelance search clerks. They will go, they will get copies of all the title deeds in the matter. And the title search basically is a story or history of the particular parcel of land over a period of at least 20 years, because 20 years is what we consider adequate timeline for us to be able to show that that there is good title to the property. Sometimes we have to go and do searches that are longer than 20 years, and that would be where we have not found a document within the title that we had seen in that 20 years that would be accepted as a good root of title. And good roots of title are matters such as a conveyance or a mortgage, and those are documents that we look for to review to make sure that they are good as they are in order to be able to confirm how the title is. All right. We will also be looking at other documentation that would be supplied to us. We would ask for things like approval documents. We would look and see whether the property is leasehold and freehold to make sure that the lease rent, if it's leasehold, to make sure the lease rent is paid up to date. If it is there any particular restrictive covenants within the title that would not allow you to build a multi-family dwelling or to use the property for commercial purposes. And those are important matters for us to bring to your attention as early as possible so that you're aware of how the transaction is going to be dealt with. A lot of properties right now have management companies, so we would also want to make sure that we make requisitions of the management company to confirm that all the service charges are paid up to date, and that the vendor is not in breach of any of their covenants on the lease. That's where a leasehold transaction, because that will be necessary to be fixed in most cases before we would counsel you to purchase the property. We don't want you to take the property with an existing problem if it is possible to avoid it. It's also important when we're looking at these things is at the title documents and all the other documents is to look at things like valuation reports, to understand the age of the building, to know whether or not getting town and country approval or a copy of the completion certificate from the regional corporation, if those things are necessary as part of the investigation of title and giving you advice and guidance. Most attorneys, if they are doing cash transactions, will take a payment on account. Usually, they will, if they are working through, if the instructions have come from one of the mortgagee clients, then what tends to happen is that the work is commenced without an upfront payment from a purchaser. Okay. The title searches take about a month to be completed, more or less, depending on the condition of the records, how far back we have to search, the type of land that we're looking at, etc. And once the report comes in, it has just come in, it will then be read and a report will be provided to be able to let you know, well, if we think the title is fine, or no, these are the additional documents that we're going to need, or this is a situation where the title needs to be fixed or rectified, and give guidance as to how that could be done, how long it would take, etc. So those are all matters that we look at in this whole conveyancing transaction, and are very instrumental to impressing upon clients that getting an attorney involved, and particularly an attorney with experience in this area of law, is one of the best ways of protecting yourself against all the things that can happen. Now, of course, I'm not going to make it out to seem that all convincing attorneys are infallible, that we don't make mistakes. Everybody makes mistakes. We're all human, but we try our best not to make mistakes. And because we have experience in the area, we know better what questions to ask and what things to look out for and what guidance to be able to give you. Next. Okay, so the important thing to understand is, and this is one of the highlights of the presentation, was when do you sign and when do you pay? So you sign the agreement for sale once it's prepared and settled, etc. And on the signing of the agreement for sale is when the deposit would be paid. That 10% deposit, it's best not to pay over money until you have some kind of binding contract. The payment of the money does not create a binding contract for the purchase of the land. It will create a situation where the vendor has an equitable contract with you, but that's not what you want. You want a fully binding legal contract that can be enforced against the vendor in different circumstances. Okay. During the process of doing the title searches, etc., once the title searches are done, you will then get your requisitions on title, which is basically like a shopping list of items that are to be provided. If there's a mortgage over the property, then of course the vendor will have to get a release and a statement from his bankers advising how much is due and outstanding in respect of his loans, such that needs to be paid off. And that's an important consideration, because you don't want to be in a situation where your vendor has a mortgage for $2 million and the balance is 1.8, but he's selling the property for 1.6, because the question will then arise, where's the additional 200,000 going to come from? And if it is that the amount that is due to the mortgagee, the vendor's mortgagee, the vendor's bankers, is less than what the person is selling the property for whatever reason, then you now need to ask the question, well, does the vendor have the money to put the difference in? Because we wouldn't be able to tell you to go ahead and pay your purchase price, even though that was a contract between you. And the reason for that is that the bank who is owed money is not going to release the property from the mortgage unless it has been paid all its money. All right. Additionally, the vendor is going to be able to have to show that he has paid the attorney's fees for the release. We also need to understand, is there anybody else who's entitled to any part of the purchase monies? So is there somebody who has an interest in the property that you weren't aware of before and that they need to be paid off? One of the things that will come up in the title searches and which create concerns for us is the imposition or the registration of a judgment or a lis pendens over the particular property or the vendor. And that judgment creditor would need to be paid off or the lis pendens removed before the transaction could be closed. Right? When all the matters are settled and the purchase monies has been paid, at that point in time, will the keys be available for release to you for you to then go into occupation and possession of your premises, which is, of course, what we are trying to achieve. Next. Okay, so whilst we have arranged for the deed to be signed, the purchase monies to be paid, look through all the title and requisitions, etc. After that has happened, we still have a few things that we need to sort out for you. And that is where we need to get the deed stamped by the Board of Inland Revenue, because in order for the deed to be registered at the land registry, the deed must be stamped with whatever stamp duty BIR deem is applicable. And of course, I'm going to go into that in the later part of this the presentation to understand, and then of course to register the document. And once the deeds have been registered, the attorney will obtain a certified copy of the conveyance document for you, and put together a package for you. Once you have that package, of course, you then have little obligations that you have to see about, such as going to the warden's office, going to TNTech, going to WASA, and being able to get your name changed on those accounts as being the person recognized as the owner of the property. Of course, if you have a mortgage, then copies of your mortgage deed will also be provided to both you and to your lender, so that they have that also on their records until such time as you have repaid the debt. Next. Okay, so I know that this presentation was really dealing with the purchase of property, but I thought it important to just, put in that the process is more or less the same if you're a seller. As indicated before, it's always a good idea to get an attorney involved to act for you, to give you guidance, to assist at liaising with the purchaser's attorneys, to review the documents, the contractual documents, to make sure that the contracts are fair to both sides. And then, of course, helping to organize the completion, payment of monies, etc. You don't want to have a situation where you're finding out at the last minute that the purchaser's documentation is not in order, or that they haven't asked you for something that is critical. And of course, you weren't aware that this was needed because nobody came and asked you for it, or they've asked you for documents 3 or 4 days before you're expecting to be paid. So an attorney would be able to give you guidance as to what needs to be done to allow the transaction to be completed and flow as stress-free as possible and without any hiccups, etc. Or also, if there are particular instances of things that needed to be sorted, they'd be able to give you guidance early enough in the transaction so that there's no further delay in getting the transaction closed. So it's important. Ask questions, do some research, find out who are good attorneys. And of course, if you're purchasing or if you're selling, or if you're just doing what is called an equity mortgage where you already own and going for financing, that you also always have an attorney look over documentation for you. The one thing that is of critical importance is that in law, once you sign, you are deemed to have read, to understand, and therefore you are bound. You can't say, oh, well, it wasn't explained to you, or you didn't understand the document, because one of the things that as someone entering into a legal contract, it's always a very good advice to get an attorney to give you what is considered independent legal advice outside of any mortgage company or working with a vendor. In purchasing property, it's always a good idea to have your own attorney and not to go with the vendor's attorney only, but to have somebody to be looking after your particular interest to guide you through the process. Next. Okay, so one of the things that we want to understand is legal fees and stamp duty. So that as the conveyancers, our fees are prescribed by law. So the Legal Profession Act contains what are called the non-contentious remuneration rules, and sets out how attorneys are to charge attorney for the preparation of documents in a particular transaction. All right, so what I've done here is I've done a quick little table to give you some idea as to what for different transactions, what you could expect your attorney's fee to be, what you would expect the stamp duty on the transaction to be. And then of course, because we now have a first-time homeowner exemption from stamp duty, to see how much money is saved by the fact that you would be a first-time homeowner. So I mean, the one thing to look at is if you were purchasing a property for 2.25 million, whereas if you are not a first-time homeowner, your stamp duty is 74,500. Where you were a first-time homeowner with the benefit of the first-time homeowner exemption of 2 million, your stamp duty would be 12,500, which of course is a dramatic difference in the closing costs that would have to be paid. Whilst I've given you some kind of guidance of attorney's fees in this matter, what is not included here would be what we call the disbursements. So payment of monies with respect to registration, affidavits, copies, if consents need to be applied for leasehold properties, the cost of applying for the consent, the cost that lessor may charge for issuing the consent, and then if there are any other additional duties. Now, these fees are respect of the actual conveyance document. Attorneys are free to charge their own, what they deem necessary in respect of an agreement for sale. Standard fees for an agreement for sale can range from about $1,500 to $2,500. Very complex transactions may have higher attorneys' fees, but those are kind of the mean figures that you would be looking at in terms of the costing for the preparation of an agreement for sale. There are different fees as well with respect to deeds of release, etc. And they are worked out differently, but I thought that that was going to be quite complex to put all of that into the presentation, to start going into the maths of how, what would be the fees on a deed of release and any other incidental documents. One of the things that your conveyancing attorney should be providing to you at the beginning of the transaction is some kind of estimate as to what you could expect to pay in attorney's fees and stamp duty for the transaction, and also to give you guidance as to whether or not the exemptions from stamp duty would be available for the type of transaction that you want to buy, the type of property that you want to buy. The following slides are going to give some kind of indication on that, and we'll now go on to the next ones where I've started to look at the exemptions that are available in respect of the different aspects of land. So the one that most of us would be looking at, and what is important in this transaction, would be where we were talking about the purchase of a residential property. Okay, so residential property has an exemption for everybody, whether you're a first-time homeowner or not, whether you're not a first-time homeowner, of $850,000. So what that means is that if you are able to secure a property for $850,000, then the stamp duty is likely to be assessed at nil. The residential property is land with a building on it, and which is different than land only. And I will go on to what are the stamp duty costings in respect of land only. In order to be able to get the benefit of this residential property exemption, there are certain documents that must be supplied. And I mean, these are generally going to be provided as part of the whole requisitions on titled documents that I mentioned, save that your BIR file number is needed, and a valuation report of not less than 6 months old is also required. The vendor is under no obligation to provide a valuation report for his property, and the securing and procuring of a valuation report is your responsibility as a purchaser, because you're not going to be able to get the deed stamped without the valuation report being supplied. It is possible to not have to procure the services of a valuator to get the property valued. And the only way that happens is that you make the request of the Valuations Division of the Board of Inland Revenue to do the valuation. There's no charge to you monetarily. However, the length of time that the Valuations Division will take to provide you with a determination as to what is the stamp duty payable, in my experience, it tends to be upwards of a year for the Valuations Division to provide an assessment of the stamp duty payable. And that's not going to be of great use for you where you are looking to take the services of a mortgage company, and no vendor is going to be waiting for you to get an assessment of the stamp duty payable. That's not something that he needs to be concerned with in the sale of the property. That is your obligation in getting the deed, in having the deed assessed for stamp duty and paying the requisite stamp duty in order to have the property transferred to you. So that our recommendation is always get a valuation report, make sure it's not more than 6 months old, and go to a reputable valuator. Now, in determining the value of stamp duty, the Board of Inland Revenue is entitled to be paid stamp duty on the hire of what you've agreed to buy it for or its value. So that if it is that you are agreeing to buy it for $2 million and the valuation comes in at 2.5, whilst you have saved 500,000 on the value, so you now have an enhanced value, but you didn't have to pay so much for it, so you got it at a bargain, you are going to have to pay stamp duty on the higher value of 2.5. Next. Okay, so we were talking about the first-time homeowners, and you will see how the stamp duty from the earlier table showed the big difference that first-time homeowners are getting with respect to the exemption that has been granted. So a first-time homeowners exemption is granted to persons with the exemption form, the other documents that would be standard for the residential property exemption. The two things that are different in this is that you must have a statutory declaration and a copy of your ID supplied in order to be able to get the benefit of the exemption from stamp duty. Now, stamp duty does make checks, and they will look and see whether or not you have in property. Otherwise, I'm not sure exactly how they do their checks, whether they go on the PBRS system, which is the Land Registry's online registration system for deeds, to be able to check and see if there's anything in your name, and they may send it back with queries and say, well, no, you're not a first-time homeowner. They may have other requirements that they want you to fulfill to be able to satisfy them that you are eligible for the first-time homeowners exemption. Most times, once the documents are supplied, as in the normal documents are supplied, the exemption is granted. We would usually have to provide a letter from a mortgage financer confirming that you're taking a mortgage and that you've been approved as a first-time homeowner as well. So those the documents that you have to supply for in support of the statutory declaration will be notified to you by the attorney preparing the document, because the attorney who is doing the conveyance is the one who will prepare the statutory declaration and provide it to you so that you can swear it, and they may arrange for it to be sworn, or they may tell you, well, you have to go to a commissioner of affidavits and have it sworn. Okay, next. Okay, so residential land is land that has approvals, and it's approved. It has a document from the Town and Country Planning Division that verifies that it is approved for residential use. And if you purchase land that has the benefit of the residential land approval, then you are able to get the benefit of these exemptions. And the difference between buying land that is residential land and land that is deemed unapproved or agricultural or commercial is that, like property, you have bands. So your first 450 is exempt, the next 200,000 is at 2%. So if you're buying a piece of land for $650, your stamp duty would be $4,000. If you were buying a property for $850, your stamp duty would be $12,000, and then after that, it would be the difference at 7% plus 12,000. Okay, and then of course you have to provide similar documents as indicated here as to what you're getting. In all instances, you're seeing that the valuation report is necessary. So whether it's land only, whether it's residential property, you are going to need to provide a valuation report in all instances for the deed to be assessed by Board of Inland Revenue for stamp duty. Next. Okay, so this is the one where you don't get any exemptions from stamp duty. That is where you have unapproved land, because it will then fall into commercial / agricultural, because residential land is land that is approved for residential purposes. And so it must be what is called a bona fide plot. And it must have a Town and Country approval confirming that it has been subdivided, or that it is in an area for residential land, and that it would then get the benefit. So any land that you are buying that doesn't fall within those confines is going to have stamp duty done on these rates. And you could see that the big difference is here. I mean, you're buying a parcel of land for $400,000. Your stamp duty is going to be $28,000. Whereas if it was approved land, the stamp duty is going to be you're going to be exempt from stamp duty on buying a parcel of land for $400,000. So whereas if you were looking at a parcel of land for $800,000, your stamp duty on that would be $56,000 as compared to a nominal less than $12,000 in stamp duty. So there is a big difference, and which is why we would always recommend and provide guidance as to the types of documents that you need and the costings that you would have with respect to the transaction when you are now entering. And these are all important considerations when you're looking to buy your property, because it's one thing to be able to find and procure the money to pay the actual purchase price, but you also need to take into consideration all the closing charges, your attorney's fees for preparation of the documents, the search fees, the disbursements, the stamp duty. Those are all matters that must be factored into when you're budgeting what you can afford to buy. Next. Okay, so now we're talking about mortgages, and I've provided this here, although as you will see that any mortgage that you take with a credit union is by law exempt from stamp duty. So you could borrow $18 million on a credit union mortgage, and your stamp duty is nil. But I thought it important so that you would be able to see that the difference as to what the stamp duty would be if you went to a financial institution that is not a credit union. And basically the stamp duty rates are fairly fixed. You will get an exemption from stamp duty for mortgages where you are using the mortgage to buy residential property. That's the one with the building on it. You will, up to $850, the mortgage will be nil, it will be exempt from stamp duty. After that, then you'd pay 0.2% on the whole. If you are buying land only and you are using the mortgage to buy the land, it will be at 0.2%. If you already own it, it is at 0.4% across the board. All right. In order to be able to get the exemption for stamp duty for where you are now buying, then you have to be able to show the either a stamped copy of the deed of conveyance or the assessment, so that then the Board of Inland Revenue will be able to confirm what is the stamp duty applicable in the particular transaction. I think I have one more slide, which, yeah, so this again comes to the stamp duty for first-time homeowners where they're taking residential property, to show that the exemption from stamp duty for first-time homeowners also extends to the mortgage up to $2 million. All right, so if you take a mortgage more than $2 million, then of course you will pay stamp duty at 0.2%. All right, but to be able to get this one, then you must have the letter from your financial institution confirming that the mortgager has been granted facilities as a first-time homeowner. And I think that's it. I don't think I had anything else after this. Next.
Okay.
Right, so that was the end of the presentation, and thank you all so much for listening so attentively. And I hand you back over to Kellyanne.
Thank you so much, Helen. Thanks much for such a thorough and informative presentation, because I think you touched on almost all the various legal processes and the different documents that are really involved in this type of process, both buying, purchasing land and property, as well as selling. So now we would like to open up the questions and answers segment, and a reminder to the members, if you have a question that you would like to ask, you can raise your hand and we will unmute your microphone so that you can ask the question. Alternatively, you can use the chat box to type your question. So we do have the question and answer segment open for your questions. Okay, I'm seeing Curleen Joseph is raising her hand. So can we unmute Curleen's microphone so that she can ask her question? Curleen, are you able to unmute your microphone to ask your question?
She's answered no, she hasn't able to unmute it.
He
She's
hasn't
gonna have to
able.
unmute on your end.
Yeah, Curleen, on your end, Andavel, can you, are we able to unmute for her? Okay, while we're trying to sort out that little technical part, as soon as we're able to unmute your microphone, Curleen. Okay, so IT support is saying that you can unmute. So if you can just look for the icon to unmute your microphone, it should be at the top of your screen. You can go ahead and ask your question. Okay, while we're waiting for Curleen, I'm seeing a question coming in from Maurice. And the question is, if I already have property and I wish to buy another property, that is house and land, will I be able to qualify for first-time homeowners exemption for stamp duty?
Okay, so it's a bit of a gray area in the fact that the Board of Inland Revenue has not given us explicit guidelines as to who is eligible for the first-time homeowners. Generally speaking, the statutory declaration will recite that you don't own property anywhere within Trinidad and Tobago and anywhere else. So that once you own property, my recommendation is always we can try, but you need to be aware that you may not be eligible for the first-time homeowners exemption from stamp duty, even though what you may own is just land and what you're buying now would actually be residential property. So it's kind of a gray area as to whether that is. So but when the question is asked, I say, well, we'll provide the documentation to the Board of Inland Revenue and let them make the determination. And once the determination is received, we would advise you. But I would tell you, budget for not getting the benefit of the exemption in your particular instance. And of course, if you do get the benefit of the exemption, you treat it as a bit of a bonus and say, okay, great, well, you're able to save some money.
I'm seeing here, Helen, you put an additional comment that the initial property was for land only.
Yeah, so that's what I'm saying is that I have had colleagues be able to get the exemption in a situation that you've presented. For me personally, I have not had that experience. Being able to get the benefit of the exemption where somebody owns land but is now buying residential property. We have asked the Board of Inland Revenue on several occasions to provide us with clarity and the list of requirements for the benefit of the exemption, but that hasn't yet been forthcoming, but we continue to ask the question.
Thanks, Helen. I have a question here from Stanley. He's asking if you can elaborate on the types of property, for example, freehold, leasehold, etc.
Okay, so freehold land is what a lot of people consider the better land, and it means that you own the land outright. Leasehold land is different in that leasehold land gives you the exclusive right to use and occupy, the exclusion of anybody else, including what would be deemed to be the lessor or the owner of the freehold reversion. But both freehold and leasehold land have their own peculiarities, and they have things that are good about them and things that are bad about them. Freehold land can have restrictive covenants, so telling you, well, you're not able to do this, or you're not able to do that, you can't use the property for this purpose, you must build a house within a period of time, etc. But freehold covenants are more challenging to enforce at law where persons don't abide. And one of the things that is hardest to enforce is you buying into a residential area and somebody in a freehold development, and somebody comes and decides, well, they're going to open up a garage next to you. And that is one of the challenges with freehold property, in that in order to take action against them and to have them desist from operating the garage on the land next to you, of course, you're going to have to go through an attorney and bring a case in court, which is expensive. Whereas with leasehold, once the covenants are usually binding on all the owners within the leasehold development and enforceable by by any of the owners within the development against somebody who's in breach, which is different than the covenants, the restrictive covenants on freehold land. So I'm going to go into a bit of technical law here. So when you buy a parcel of freehold land that has restrictive covenants, the person who can enforce the restrictive covenant against you is the original seller. All right. So when the land goes down to when it gets sold several times, there's no privity of contract between the original seller and the new owner. So yes, there are terms where you say that you agree to be bound by the covenants, etc. But it's a lot more, which is why it's harder to enforce the freehold covenants against those who are not complying. And whereas leasehold doesn't have that benefit, but of course you then have this instance where you have the right to use the land for a specific period of time. Most of the upscale land developments that you would know about in Trinidad and Tobago, which are leasehold, do tend to have long leases. So a long lease would be anything 99 years and up. And the practice right now is to do 999-year leases, which is as good as you're going to get in terms of leasehold land. So I hope that clarifies the different types of property adequately for you.
Thank you, Helen. I'm seeing Curleen is saying her microphone is working now. Curleen, would you like to ask your question?
Yes. Hi, good evening, everyone. Are you all hearing me?
Yes, we are.
Yes, we are.
Okay. So, in the presentation, you would have alluded to the fact that when persons are engaging in purchasing of property, when they sign, I mean, ignorance is no excuse to the law, right? So, when they sign, it means that they understood all the particulars therein within what they are signing to.
Well, they are deemed to have understood.
Right. And again, from where I said, black and white beats verbal any day, right?
Yes.
So
And
I
as
had
lawyers,
a
we would agree.
so I'm listening to the presentation and a lot of questions is popping up, making me think if I need to have someone review my portfolio, 3-year-old portfolio in terms of acquiring property, right? Now,
Uh,
when I
I don't
asked
understand
the
what you mean by review your portfolio. You already own the properties?
correct, right? Now,
Okay.
when initially I would have engaged in that and I'm very grateful for this what Cannings is doing here. It is awesome, and I can't. It has saved me the information here. I've been attending every time you guys have it, and it has saved us tremendously from a lot of red flags. Right
Excellent. I'm
Happy
very
to
glad
hear
to hear
that.
that.
now, I attend it every year because things are updated as time goes. So you could never tell new information is golden, right? So initially, my question is when I was going through the discussions with the attorneys, a lot of big law jargons were used, right? And I would have asked the attorney, could you break it down for me in terms of layman terms? Because I may not understand, based on how it's placed in the contract, what it really means, right?
Mhm.
And the contract, when they took a while to break it down for me,
Mhm.
and then obviously I was told that I was the most difficult customer because I made them explain every single thing. But um, can it be that the lawyers could possibly look at creating a narrative? Is the same law, but you break it down for the common man to understand? Because it would save you all a lot of time. So that's just my question. Is that possible that that could be done within that industry? put these
So,
jargons broken down.
so basically what you're asking is you want us to start using plain English.
Yes, the dowards and the whence and the that could really tie up somebody and end up making them sign to something. And then
Uh-huh.
I'm not going to be much longer. When it is you're in the transaction at a certain point, I was advised that you can't really turn back, because if you turn back, you forfeit your 10% to the person who you did the agreement of sale to for the property.
Uh-huh.
Right? So at one point, I kind of felt that I'm kind of between a rock and a hard place, because if I now started to hear things that I'm not comfortable with that was being explained, how is the proposed buyer to be protected in that instance? Because a 10% is not just like $10, it could be a lot of money. And if I am now in at this juncture in the transaction, and the information that is now coming before me, it is not comforting to me, and I no longer want to proceed, I'm basically being told that I'm forfeiting my 10%.
You're relinquishing, not forfeiting.
Okay,
But
right.
yeah, okay, so that's why it's important to have an attorney look over the documentation for you, acting on your behalf, and to give you guidance and to get independent legal advice. In terms of whether or not you can resile from an agreement for sale because of particular circumstances, it would be challenging for me to give you guidance, but I can say that there are circumstances in which you would be able to resile without losing your deposit, but it would require an examination of the facts in your particular instance as to whether or not you would be able to walk away from the transaction without losing your deposit. All right, and I didn't indicate it during the presentation because I really wasn't talking about the particular forms of contract. But one of the things that I always like to recommend to clients when they're buying land is to please put a deposit in escrow, so that if something goes awry during the transaction, either on the vendor has a title problem or the vendor delays in providing the documentations that are required, etc., that your deposit is protected and is available for refund if the vendor defaults on his obligations under the contract. Okay, so Killian, I hope that I've been able to give you some guidance and some comfort, but it sounds like you need to have somebody look over the documentation and give you some kind of independent advice as to the particular transactions that you had entered into and the land that you hold, as to what are your obligations and restrictions, etc., that may pertain inside of there, as well as whether or not there was anything that can be done. As conveyancing attorneys, there have been changes since the last time. So, I mean, more and more we are seeing, you would have seen court cases within the public sphere showing that attorneys may not have done all that they should have done, or that they should have asked the necessary questions, and that by reason of that they are liable. Okay, so it's important to understand that we as attorneys in doing conveyancing transactions, we have a responsibility to our clients. And that is a responsibility that I take very personally, that I take, it's a very strong commitment on my part, that I always try to do the best of my clients that I can, particularly with the information that I have and the knowledge that I have. But sometimes you will be with somebody who doesn't know, but they don't know that they don't know. And that's the danger. And that is why it's a recommendation to try and get somebody who understands what they are doing, has experience in a particular field, so that they are more likely to know what needs to be asked, and also to appreciate that they may not know everything, and to ask the additional questions and to do the additional inquiries that sometimes may be needed for your protection.
Thank you, Helen. So we have another question that's come in here, and it's in reference to one of the slides that you may have had up. It says, if a property was inherited and the person who inherits wants to sell, but they have an outstanding court matter regarding reimbursing family members for renovations, would the property be able to be sold, or would the matter have to be closed first before sale?
Okay, so that's a very complicated question.
Yes.
So let me try and make sure I'm understanding what the particular scenario is.
Mhm.
You've received property
Through
from
inheritance.
mother, father, etc.
Mhm.
But the property was the subject matter of a court case, and there's a court order issued in respect of the particular property. Is that what has happened? If you could provide clarity.
That one I'll have to get because this one came in not in the chat.
Oh, okay. So that
Yeah.
if it is that there is a court order
Mhm.
directing how sale proceeds are to be paid, then to act otherwise and in accordance with that court order means that you're in contempt of court, and that you could be sued for breaking the contract. And if I am aware of a court order in a transaction, I will want to ensure that the instructions contained in that court order are followed to the absolute letter. I don't have the authority to interpret it in any which way. I have to go with the actual letters of that, how it is explicitly stated in the court order. I don't have the ability to interpret it in a way if the wording is ambiguous. If it is that it's not clear, etc., it may be that you'd have to go back to court for the court order to be varied for greater clarity to be provided, so that on the sale of the property, yes, you would absolutely have to deal with the matter that was the issue, the subject matter of the court order. That would form part of the whole sale of the property.
And if it's not a court order, so I'm seeing here that the matter is in the court, so it's been filed, but no order has been issued or anything like that.
Well, if a matter is before the court, then my comment would be, don't rush to give your money over, because you could then be, particularly if you have knowledge of it, you can't say
Yes.
that you are what is deemed a purchaser for value without notice, and
Right.
that you would then be deemed by the court to be aware of the particular circumstance, or at the very least that you should have at least been put on notice and asked additional questions to protect you.
Okay, great. Thank you, Helen. So we have questions coming in now via the chat. So Stanley wants to know, what is the easy, cost-effective process to get the release after the mortgage is paid off? And what is required to get the copy of the title?
Okay, so I'm not sure what you're talking about, cost-effective process to get the release, because again, fees for conveyancing transactions, including deeds of release, are prescribed in law, and the stamp duty is set by law, so that there should not really be a variance between attorneys as to what is charged. There may be nominal variances in respect of the different disbursements and the value of disbursements that are charged for the transaction, but the attorney's fees for a deed of release should not be increased. Or should not vary. So one attorney shouldn't be charging you 5,000 and another attorney charging you 25,000. That's not what should happen. Important to understand, though, that if you go to your own attorney to prepare the deed of release, which you're fully entitled to do, the mortgage company that the loan was with is entitled to have its attorney vet and review the deed of release document, and those fees would also be for your account. So that my recommendation is, if you're going to go to your own personal attorney, bear in mind that you will also have revision fees to pay. And what is required to get a copy of the title? I'm assuming from that you want to get a copy of your deed of the title deed for the property that shows you as the owner. A copy of that should have been provided to you by the attorney when you purchase the property, whenever. If you don't have it and you do have the deed number, you can either go into the Registrar General's department and let them know that you want to get a copy of this deed, or go to an attorney's office and ask them if they would be able to assist in procuring a copy of the title deed, a certified copy of the deed from the Registrar General's department, the cost of which that attorney would advise you on. I know that our charge at the office is $250 plus VAT to order a certified copy. So those are the options available to get the title deed document.
Great. Maurice is asking, what's the approximate cost to change my deed from common law deed to RPO?
Okay, so you can't change your deed, your property from common law to RPO by a document. What you would have to do is you'd have to make an application to bring the lands under the Real Property Act. That is a process. It can take anywhere from 6 months to 2 years. From what I understand, attorneys who do those applications charge between $15,000 and $30,000 for the application. There are other documents that you're going to need to get. You're going to need to have the property surveyed. Those plans need to be approved by the Director of Surveys. But I'm not understanding, why would you want to go from common law to RPO? Unless, of course, there's a title issue that, or all you can show is that you have good possessory title to the property, and therefore bringing the lands under the RPO is going to allow you to get good title to the property. But that sounds like, if you wanted to get some kind of a guidance on that, then you definitely need to take your documents to your attorney and get them for advice as to what is the best way forward.
I scroll down to the same, Maurice put an additional comment here, so I'm skipping forward and then I'll go back because it might assist with what you're saying there. He said, if I bought a parcel of residential land, which I already paid under deed of mortgage, however, after checking Lands and Deeds Department, the size and parcel of land, according to the survey plan lodged at the Lands and Deeds, is less than what is stated on the deed, is it responsibility of the conveying attorney to resolve this, or is it my liability to have a new survey done? And with regards to the common law and RPO, he was saying only because it's more secure.
Okay, so I'll deal with the latter statement before the first one. I'm not sure what you mean by more secure. RPA property that is held under the Real Property Act is backed by the Land Assurance Fund and the title is certified by the state, but I'm not sure what you mean by more secure. It has its benefits, just like common law deeds. It is, in terms of secure, maybe what you're meaning is that there are less instances of fraud with the real property land.
That's what he's saying here.
Real Property Act. However, I wouldn't say that that is stating that RPA documents cannot be forged is erroneous, because they can, they have, and it becomes a whole different question as to how you treat with land that has been fraudulently obtained under the Real Property Act. Again, you have to go to court. You'd probably have to get the police involved in respect of fraudulent land. In talking back now, where you want to know what happens when you got a survey done, and the survey plan shows that the property is less than what is stated in the deed. It all depends on when the survey was done. If you did your survey subsequent to purchasing the land, then you would need to go back to the attorney who prepared the document and ask them, is there anything that could have been done about this? Is this something that they should have, been aware of? Particularly, it's important also to understand that there are descriptions in deeds that talk about a lot of land. A lot of land is not a specific size. So lots of land, we understand lots of land to be 5,000 square feet now, but a lot of land in 1920 could have been 10,000 square feet of land. So that a lot is not a size. And my recommendation, when I realized that land hasn't been surveyed for a long period of time, is always to clients, we suggest that you go and get a survey done so that you are clear as to what are the boundaries. And that is one of the things that, when I was talking about the checks that a good residential attorney will talk to you about, is understanding whether or not a survey should be done, because the survey is when you will understand the true size. You can also sometimes have errors in terms of where you think the property is and what is described in the deed. That does happen, and that's a serious concern, where you think you have bought the parcel of land that is, nicely situated, three lots off from the corner lot. But when the deed is looking at it, it's no, it's not. It's some parcel of land on the opposite side of the road. It's backed by a river, etc. So I mean, that's what the attorney needs to be looking at. And I have always found that surveys are tremendously helpful in helping us identify what particular peculiarities there are of the land, if there's any encroachments, etc. But the caveat that I must put in here is that there is no way that I can determine from a deed whether the property that you are looking at is what I am seeing on the deed. That is one of the ways that a surveyor assists in providing that clarity. So I hope those answer your questions, Maurice.
Thank you, Helen. We have a question here. When purchasing a property via mortgage, is it advised that you have your own attorney, even though you have the use of the bank's lawyer?
Okay, so when you're purchasing the property, it's always recommended that you have somebody who looks after your interest. You need to appreciate that the bank's lawyer, the client of that attorney, is the bank. All right. And that they will, whilst your interests and the bank's interests may align, there are times when your interests and the bank's interests don't align. And in that instance, the attorney will usually let you know that, well, you need to go and get advice. So it's always a good idea to have an attorney provide you with guidance, etc., in the transaction. And I'd like to hope that we don't have too many instances where bank attorneys don't provide you with good advice and don't provide clarity. But when it comes down to advice in a mortgage transaction, I will always say I can clarify aspects of a deed, so I can explain the deed to you, but I can't advise you of the risks and liabilities and implications. That is something that you need to go and get independent advice about. And most bank officers will, and mortgage loan officers, they will advise you that you should get independent legal advice to make sure that you are aware of what your obligations are in this particular transaction.
Thank you, Helen. Stanley's asking, is RPO different to freehold and leasehold, or is a summary?
Okay. Land law in Trinidad and Tobago is held under two different, what you would consider laws. So you have the Real Property Act, which is what guides and defines the rules and practices for land that is held under the Real Property Act. And land held under the Real Property Act has a certificate of title, and it is backed by the Land Assurance Fund. And that if you have been disadvantaged, and you can show that you were disadvantaged even though you had an interest on the deed, then you can make claims against the Land Assurance Fund. Land that is however, RPA land can be either freehold or leasehold. Freehold or leasehold is not confined to land that is held under the common law. So freehold or leasehold can exist over both leasehold, both RPA and common law. And you can sometimes find that you will have a parcel of land that comes out of larger parcels of land, one of which was old law, one of which fell under the Real Property Act, in which case you will then have two documents that together comprise the title for your property. Okay?
Great, thank you, Helen.
There's some other question, but I think that question is for you.
I was going to say, I'm to me. Could you remind us of the links between part 1 and part 2 of the recording? So essentially part 1 referenced more of the actual mortgage, planning for the mortgage, the property search, the mortgage process and application at SECU. And part 2, because it is, as I said, the biggest investment you'll make in your life, and there's a lot of legal work behind it. And from Helen's presentation, You can see all the different documents, all the little things you have to be aware of, and lawyers do need to get involved. We thought it would be helpful in the second part of this seminar to really just address the legal aspect of purchasing property. So that's really the link between the two.
Okay, so Stanley has asked, what is the RPO Act? That is the Real
Yes.
Property Act. So the Conveyancing and Law of Property Act, Chapter 5601, is what governs transactions under the old law, and as well as the whole body of common law that has evolved over several centuries, because our common law practices have come from English land law, and that is where the common law will come from. So it's not everything is in the Act in terms of common law. Everything that deals with Real Property Act comes out of the Real Property Act, Chapter 5602. And they're two different bodies of law. And so you can't have a deed for land that is held under the Real Property Act. Your title document for property that is held under the Real Property Act would be called a memorandum of transfer, a memorandum of lease, a memorandum of gift, a memorandum of mortgage. That is what the title documents and the documents that relate to land held under the RPA are. Where lands are held under the common law, then they talk about a deed of conveyance, a deed of mortgage, a deed of gift, a deed of lease, etc. So I hope that gives you some differentiation. But the two bodies of law exist side by side within land law in Trinidad and Tobago. So it's two different laws that govern how you can own land and the requirements for registration and etc. Within Trinidad and Tobago.
Great. Margaret's asking Helen, if there are two houses on one lot of squatting land with a deed of comfort, can one be rented or sold?
So your question, Margaret, and I'm going to ask you to put that in the chat, is are you asking if the house can be sold, or are you asking if the land can be sold? Because if you're asking if the house can be sold, absolutely, you can do what is called an absolute bill of sale, and you can sell a chattel house. Who will want to buy your chattel house is a question. A deed of comfort is not a title document. It is just something that says that you're entitled to an interest in the land, but it's not binding on anybody. And it's definitely not land that would be recommended as suitable for mortgage purposes. Okay, but if you're on squatting land, you need to appreciate that the owner of the land that is being squatted on has rights, and unless you are able to show that their rights have been superseded by yours, of course you have to go to court and get declarations from the court in respect to, in that regard. You can't just say, well, I've been here for how many ever years, and so the other person's rights have gone and I now have those rights. No, that's not how it works. Your rights exist and their rights exist, and the court would be the one who would be able to give the judgment as to whether any one person has a better right or not. And then if you are on squatting land and you are able to get an order that says that you're the person that's entitled to this, then what you need to do in order to get title to the land is you have to make an application to bring the lands under the Real Property Act.
Great, thank you, Helen. So I want to ask one or two little additional questions and kind of bringing it back a little bit to actual mortgages and stuff that happens every day sometimes when we're dealing with members and all of that. And in recent times there, and you have said it, there are a lot of developments taking place now, a lot of, you know, apartment buildings, gated communities, all of that. And there are a lot of instances that are coming up now where we know to ask for, I mean, we have the checklist, town and country and regional. If it's one thing, you guys are not, you don't let us close anything without that town and country and regional, and what's the clearance. And there are times when not necessarily the developers, but the realtors are, you know, telling persons who might be interested in these properties that, no, you don't need that. It's less than 20 or it's more than 20 years old or something like that. And yeah, there's this, and maybe a little understanding of the importance of the town and country and regional when it applies, and the importance of that WASA clearance as well. Because when you're dealing with different service providers and they're saying, well, no, you don't need it. And then you come to the financial institution and say, well, no, we need this. Sometimes it deemed as we're just being troublesome. But I know legally we actually do need these documents because there are risks involved. So maybe share a little bit about that, the importance of those documents.
I think the first thing that I would say is don't take legal advice from someone who's not an attorney. The
Yeah.
second one that I would indicate is that you have to have a WASA clearance in all instances unless parties are willing to waive it. And the reason that we ask for WASA clearance and the land and building tax receipts and possibly property tax, which keeps threatening to come, but we haven't seen it yet, is because those are statutory charges. And by statutory charges, they are charges over the land that take precedence over anybody else's interest. And so as at the date that you are buying, we want to be assured and be able to provide confirmation that there are no charges over the land that take priority, that rank higher in priority than your interest when you're purchasing the land. So the WASA clearance certificate is one of the documents that we ask for to be able to confirm that there are no outstanding WASA charges levied against the property. Now, people sometimes think, oh, well, there's no land, there's no water on the property, so I don't need to get a WASA clearance. WASA is entitled to charge to levy charges against any land that lies within a quarter-mile radius of a standpipe. And so if there is no connection on the property, you still have to get the WASA clearance to confirm that there are no charges levied against the property, because the person may not have realized the charges are levied. And once you take it over, the charges attached to the land and the owner of the land at the time is the person who's responsible for paying it. And I don't know about anybody else here in this seminar. I don't want to pay nobody else's debt. I find they need to give it to me clean and clear. And if I've asked for this, I have a reason for asking for it. This is my experience. I've been doing this for very many years. I have, in dealing with conveyancing properties, I have close to 25 to 30 years of experience dealing with them. And a WASA clearance is something that is always required. In terms of the town and country and regional corporation approvals, the reason that people say that, oh, the building is more than 20 years old. Okay, yes, the building may be more than 20 years old, but you want to be able to get benefit of certain exemptions. If it is that the building is more than 20 years old, but at the time 20 years ago when they subdivided the land, they didn't get permission to carve up the land, then that land is deemed unapproved. And there could be issues raised with the title. And we as conveyancing attorneys, we are very risk averse. We don't like to take problems if we can avoid it, right? So that the request for those documents is definitely done on a case-by-case basis. We will look and see whether the property falls within what is considered an established development, in which case we will say, well, okay, in this particular instance, this is not something we would consider, we would absolutely require. It's always nice to be able to get it, and it's not usually challenging, particularly for land only, for the person to go and get what is called a status letter from the town and country planning division that confirms what is the approved use of the land and that the land is in a bona fide, has its necessary approvals. In developments where the land was subdivided before 1970, there would be no town and country approval because the Town and Country Planning Act came into effect in 1969. And so any land that was subdivided in 1962, 1965, 1942, etc., would not have town and country approval, and in that instance would not be applicable. But again, I come back to the point of why you should get an attorney to give you guidance real estate agents' business is selling land, showing, selling, giving you guidance. A lot of them are knowledgeable. They are not attorneys at law, and legal advice should be sought from an attorney at law for you to be better guided and protected, because there are certain instances and peculiarities that a real estate agent may not be aware of. Okay, so I hope that
Right.
helps provide some clarity.
Yes,
But,
very much, Helen.
I just wanted to provide a comment on to Maurice, who's talking about the RPA. So
Yes.
in the RPA, what happens is on the certificate of title, all the transactions dealing with a particular parcel of land are shown on the certificate of title or on the reverse. And that is where on the back of the certificate of title, and that shows who is the current owner and stuff. Title, common law transactions, you do have to go and get individual deeds. So you have to get copies of each of the deeds in the chain. So it's a little bit different in terms of searching. RPA searches tend to be a little easier and quicker to get. But of course, it's not that one is better than the other. They just each have their own challenges in being able to deal with it. And yes, but I mean, even with the RPA transactions, a new document is created every time for transfer of property held under the Real Property Act. So if I have a certificate of title in my name and I sell my property to Kellyanne, we will have a memorandum of transfer from me to Kellyanne, and there will be an endorsement made on the reverse of the certificate of title that reflects that I was the owner and I sold it to Kellyanne, and they will then give the reference information for that memorandum of transfer. And then that endorsement will now reflect that Kellyanne is the owner of the land. But I don't need to go back and get a copy of that memorandum of transfer, because the endorsement on the CT is evidence of who is the correct owner. And that's one of the distinctions between OLO and RPO. But it's not that you don't do a new document for for RPA documents. You do. You have to do what is called a memorandum of transfer and not a deed.
Great. I see T. Joseph asking, if you were gifted land along with other persons, would you be considered first-time homeowner if looking for your own property?
Not likely.
So it's once your name has been on land, regardless of however that happened.
It doesn't, it's, which is again comes back to the point of the requirements at the Board of Inland Revenue. It's important to understand that I can say that this is not my experience, but the Board of Inland Revenue is the body that has the final say as to whether stamp duty exemptions are available. And all I will tell you is we could try, but there is the fact that you have to make a statutory declaration that says you don't own any other property. And if you own property with other persons, whether you purchased it or you were gifted it, it means then that you have an entitlement, and the first-time homeowners exemption may not be granted to you.
Okay. Just a couple more questions I wanted to ask, because again, these are things that come up, and this one is more along the line of the stamp duty. If I'm not mistaken, you can correct me, Helen. Is it that we have two stamp duties, stamp duty on deed of mortgage and then stamp duty on deed of conveyance?
Okay, so the way the stamp duty is calculated on a mortgage and the stamp duty that's calculated on a conveyance is different.
Right.
All right. It tends to be the stamp duty on a mortgage tends to be, particularly if you own the property already, it's 0.4%. Not applicable, of course, in credit union mortgages.
Right, that's where I
but
wanted, yes, right.
yeah, so credit union mortgages, they are statutorily exempt from any stamp duty. So you don't
Right.
pay stamp duty for a deed of mortgage that for any property that's mortgaged to a credit union, whether you do it as a deed under the old law or you do it as a memorandum under the Real Property Act. They are exempt from stamp duty across the board. Regardless, it doesn't matter how much you borrow, whether that if you do a bill of sale as well for a vehicle, etc. There is no stamp duty payable for any documents that have to be stamped for loans granted by credit unions.
Right, and that's specifically deed of mortgage. But there is
Yeah.
still, so if you're not,
Yeah, because
If you're not a
conveyance
first-time homeowner, you
conveyance
still
is
have
not
conveyance.
a charging document in favor of a credit union. And that is what the
Right.
mortgage is. So the mortgage is you are the
Right.
owner, but you have agreed to borrow money from from a credit union, and as security for that loan, you have offered your property, whether it is a house, a piece of land, or a vehicle, and that document by which the credit union's interest over the property is notified to everybody. That document is exempted from stamp duty. But the
Right.
conveyance
And the
document by which
conveyancing may
you
still
become the
have.
owner of the property, that attracts stamp duty at the rates as I had indicated. But there are two different documents. A mortgage is not an
Yes.
ownership document. A
Mhm.
mortgage is a debt document. It shows that
Right.
I own, but I had borrowed money and that I have to now wait until the debt has been repaid before I can get the property free and clear of the credit union or the bank's interest.
Right. So Maurice is asking, and I did just need, and this is why I asked it, so that people don't feel suddenly there is no stamp duty at all. So the exemption on the stamp duty is on the deed of mortgage. But if you are not a first-time homeowner, then you will have stamp duty on the conveyancing, the conveyance document. So you're
Well,
just
you
exempted
may
from
have
one, which
stamp
is a
duty on a
smaller one.
you may have stamp duty on a conveyance document if you are a
Right.
first-time homeowner, depending on the value
Over
of
the
the
two.
property.
Yes.
So once the
Yes.
value, once the Board of Inland Revenue assesses the value of the property over 2 million, then stamp duty would be payable. The exemption just determines how much stamp duty you have to pay. So you always have to have
Okay.
a stamp duty stamp on the document. So the stamp duty stamp will either indicate that the stamp duty payable is nil or exempted, or it will indicate what is the quantum of stamp duty that needs to be paid for this particular property in order for it to be able to be registered.
Okay, great. And one little, I know we're just around the 7 p.m. Close off time, but there's another little question I want to ask, and this is along the line of valuations, because again, these are things that we see happening. And again, when you have, you know, when you go in looking for property, you're really dealing with the realtors. You tend to come to the financial institution after you found somewhere that you like and you really want to buy, and then you're in a hurry to buy it. But then you
Usually
also have
entered into the contract as well.
yeah. So you have instances where the realtors may also be pushing persons to sign a sale agreement and tie it up. But the sale agreement doesn't cover everything. The sale agreement may pick up the more legal aspects in terms of title and you know, making sure we have the town and country and the master clearance and all of that, so that in terms of paying your down payment, if those things aren't in place, you could get back your down payment. But where the valuation is concerned, sale agreements don't cover valuation, so that there is a level of importance in doing that valuation before you sign that sale agreement. Because if something is being sold for 2 million and when the valuation is done is 1.8 and you've already signed and handed over money, there's no,
Okay, so
what can I get it back?
that is an important consideration to take into to be talked
Yeah.
about. So that there are instances where you will agree with the vendor. I love this place. And it's the vendor is asking 1.8, and you look at it and say, okay, well, all right, yeah, you're stretching to get to the 1.8, and so you sign the contract and agree to buy it for 1.8, and then you go and get the valuation, and the evaluator comes and they look at it and they say, this is nice, but it's only worth 1.6. And then you are hit with a whammy in that you now have to fund $200,000 out of your own pocket, because the mortgage company is not going to finance over the value of the property. I'm not sure, Kellyanne would be able to give better advice as to what are their margins, as to what is how much they will loan up to the value of the property. So it's important to understand that the value of the property and the price you have agreed to pay for it are not always in line. and that if the value comes in lower than what you've agreed to buy, unless the vendor is willing to accept less money, that you could be in a position where you are unable to complete the transaction and the vendor would be entitled to forfeit your deposit. A reduction in the value of the property is not a reason for you to be able to be refunded your deposit. That is not how it works in law. Because which is why, again, you are deemed to have done all your necessary inquiries and due diligence before you sign on the dotted line, which is what it's important to understand, that when you sign, you are bound, and you are bound whether it's to your benefit or to your detriment. And that is where legal advice is of great importance. Now, we as attorneys don't give guidance on value of properties, but if it is that a property comes to us and we see that the value is kind of out of line and what we are accustomed seeing for properties of that kind, we may mention it to you and
All
say,
right, I'll get back
"Oh,
to you.
the price looks a little high, or,
Yeah.
more than what's normal." But you do need to understand that, as Kellyanne says, is that if the value comes
Not hearing.
I think Helen's been muted, so we're just gonna, Helen, I think you've been muted. I don't know if you muted yourself or if, let's see if we, okay, I think you're
muted.
right. Good.
So
back, yes.
where did y'all lose me?
I think we lost you for like 2 minutes.
Wow, that's a lot.
Yes, it is.
Yeah, so I mean, it's just basically to reaffirm that if the value of your property is less than what you've agreed to buy it for, that you are still bound under your contract to pay the higher price. The drop in value is not a reason for you to be able to walk away from the transaction, and the vendor would be entitled to forfeit. Do find it's harsh that a vendor would do that, but there are some persons who are compassionate and some who aren't. And that is why a recommendation of getting a value on the property is not a bad idea before you enter into the agreement for sale. However, a lot of vendors may not be willing to grant access to the property in order to have a valuation done before that. But of course, if you can get some kind of ballpark figure, speak to evaluator, speak to the agent, and see if the agent could, speak with someone. Although agents do tend to have reasonable understanding as to what values the properties are. It is that's what they deal with. They are better understanders of, whether what this property could be sold for. Sometimes they would have recommended to their client, if they're acting for the vendor, that this is not really worth that, and the vendor is adamant, but no, I want this amount for my property. And but it's important to understand that a drop in the value as against the purchase price is not a basis upon which you can step away from the contract and get back your money. Not unless the vendor agrees.
See, Joseph is asking Helen, what happens if the value of the property is more? And also some real estate agents advise to purchase pending valuation. Is that binding?
Okay, so that is that's kind of a gray area of law, because it's basically you haven't entered into a binding contract. You can make it subject to the valuation, but of course, until the valuation comes in and the a price is affirmed, then the contract is not binding against you and the vendor. If they decided to hedge their bets and try to get other purchasers, who had agreed not to enter into contract. But of course, from the time you have to start talking about enforcing rights under contracts, you're talking about legal fees in court. So that's an additional expense that not really recommended to go through. And I mean, it might sound strange that I, as an attorney, not recommending you to go to court, but But that's not my area of expertise. And court is expensive. Don't fool yourself. Court is very expensive. It's much more expensive than the fees that attorneys charge for purchasing land and mortgaging.
I see, Alicia. I don't know if it's a question or statement Alicia is making here. I'm thinking it might be a question. Is it, or well, no, she's saying it should be a vendor's responsibility to value his property before he puts it up for sale. And I think that's kind of in line with what you were saying with the realtors, that they
Okay,
do
so,
discuss
so
with the sellers.
all right. So yes, a seller could go and get their property valued, but they're under no obligation to disclose what the value was in that valuation. They don't have to share it with you. They don't have to sell at the valuation cost, right? I mean, one of the things that I often say is, and I mean, my husband says all the time, is that you don't sell bad, you know. You don't sell bad. You buy bad. Sometimes you can end up buying something for more than it's worth, but the person who has sold it, they have gotten the benefit. Okay, and so so somebody had asked, what is the difference if the value of the property is higher than your agreed purchase price, you'll pay stamp duty on a higher value.
Right, yes, so the
Then
stamp duty is always on valuation.
contract. So if you bought a property for 2 million and the valuation comes in at 2.25, all right, then you'll pay stamp duty on 2.25, but the vendor will only get 2 million. And so that you will then basically be receiving the benefit of what is called additional equity in the property, as opposed to what you bought it for and what it's actually worth. So you got it on a discount, is the best way to put it in clear layman's terms.
Yes. Okay, well, I know we've gone over a little bit, and I know members could probably ask you questions all night, Helen. But we're not gonna have that. I mean, if there are any additional questions, you are free, feel free to email me. My email was in the chat, and I can always pass it on to Helen and get a response for you. So that is no problem. Helen, we really wish to thank you for giving of your time to facilitate today's seminar and for sharing your knowledge with our members regarding the legal aspect of purchasing property, things to look out for, and even giving the cost estimate. I think that's really helpful, especially that slide with the estimated stamp duties, because that sometimes is the biggest cost. So I think that's really, really helpful to our membership, and we really, really appreciate you spending your time this evening and sharing this information with our members. We want to remind members that the recording here, as well as the presentation, will be loaded to our website along with last week's presentation and recording, so that when you want to go back and refresh, just go to our website and it will be right there. So we have come to the end of our session today, and we have come to the end of our two-part webinar series. We really hope that it has been helpful to all the members who've logged on. It's provided some clarity in terms of planning for a mortgage, taking a mortgage, and understanding a bit more about the legal process, and also opening our eyes a little bit to things that we should be aware of and look out for. Things like don't let anybody pressure you into signing a sale agreement. Make sure you check things before. Make sure you speak to an attorney. As Helen said, don't take legal advice from someone who is not an attorney, which is most important. So I hope that these sessions have been truly beneficial to all of you, and that it has been enjoyable. SECU is going to be having webinars coming up. So all throughout 2023, we are going to be hosting webinars on various topics and aspects and whatnot. So please make sure you check our website, follow us on our social media pages so that you look out for the sessions. We do have two good ones coming up in June. So on June the 1st, we are going to be having a webinar focused around personal security and safety. We are living in a time that it's very dangerous. And like me, I don't know if you're like me, I don't really watch the news anymore and read the papers because it's too depressing. So this webinar is going to be focused very much on personal security and things to do to just be more aware of your personal security and safety. That's going to be on June the 1st from, I think it's 6 to 7 p.m. And then on the 14th of June, we're going to be having a webinar that is focused around the family indemnity plan and understanding what it is about and how important that plan is, especially, covering yourself and your family in the event of death and things like that. So 2 good seminars coming up. So keep a lookout for when those registration links are sent out. And we look forward to the members logging on and learning lots more on these topics. So we want to wish everybody a good night. Helen, you wanted to say something?
I just want to kind of end with one little comment.
Yes.
Is please be careful when you are hearing about properties for sale. If something sounds like a fantastic deal and it sounds too good to be true, it usually is. And those are the ways in which the fraudsters try to catch us. And anybody who is pressing you for a quick sale and really pressuring you and it's a real good bargain and you're not going to see something like this again, just take a pause, think about it, and get advice before you pay money and sign on the dotted line, because you may end up with not only losing your deposit, but a lot of other money, particularly, and I mean, we've seen the fraud happening way too much in Trinidad and Tobago. But the part of what I was asked to talk about did not deal with fraud, but it is important to always remember, if it's too good to be true, probably is, and be careful. Don't give away your money. Don't throw it away, and don't hand it over to the fraudsters. And know who you're dealing with. All right. Ask questions. Find out who they are. And again, put your money in escrow. Don't hand it over to persons, because once you've given it to them, they put it in their bank account. If they spend it, it's not available to come back to you.
Yeah.
All right. And don't buy land by handing over large swathes of physical cash, because good attorneys and attorneys that deal with conveyancing transactions are not going to deal with transactions where you are paying in large sums of physical cash. It would be a trigger and a red flag for us. And we would be saying, no, go to the bank, get a bank draft.
And
Okay.
it's so amazing that there's still so many transactions, cash transactions for land,
Yeah,
in this
cash
day and
is fine,
age.
but cash needs to be in the form of a bank draft from the bank.
Yeah, no, that's what I mean, not a duffel bag full of $100
not
bills.
physical cash. Anybody who is buying property physical cash, that becomes a money laundering question and
Yes.
all kind of concerns. So be careful and don't put your money there. And you may have cash there at home and businesses. I don't say that anybody who has large sums of cash is involved in illegality, but if you are buying property transactions, you're going to need to go through a bank and provide either wire transfer or bank draft for the completion. Good attorneys are not going to be involved in physical cash for large sums. It's an FIU trigger.
Yeah, yeah.
Okay,
Thank
so I
you
just wanted to
so
close off
much.
with that and give you all some, just be careful.
Which we so appreciate, Helen. We really, really appreciate those little warnings, because sometimes you get so taken up by this deal is so good, you just want to get into it, and then you realize after you just lost all your savings. So we really, or that you're tied up in a transaction that really is illegal and your name is now involved in it. So we really appreciate all the warnings. And as I said, we really appreciate all the information that you've shared with us this evening.
Okay, good
So
night.
that's it, folks. We are officially at the end of our seminar and our mortgage webinar series. We would like to thank you all again for logging in this evening and last week, and we wish everyone a good night. Take care.
Bye.
Bye-bye.
Bye.